Thank you for joining today's Benefits and Compensation University webinar. Our program today will focus on developments and key issues in U.S. employment law related to executive compensation. My name is Andrew Rosenman, and I'm happy to introduce today's program. I'm an employment litigation partner in the Chicago office of Mayor Brown and co-lead our U.S. employment litigation and counseling practice. Joining me today is my colleague partner, Marcia Goodman, also here in Chicago, and a member of our employment litigation practice, as well as Ruth Zadakani from the Los Angeles office of Mayor Brown. Ruth co-leads the U.S. employment litigation and counseling practice with me. So with that, let's get started. You can see the slide with the presenters, and now we'll move to the agenda. These are the topics we're going to cover today. We'll start with the developments under federal law, including President Biden's executive order and recent proposed federal legislation. Then we'll move into the legal landscape in state law, including a recent development here in Illinois. We'll also discuss the forfeiture for competition doctrine, which comes up a lot, of course, in equity plans and other types of incentive plans. Further, we'll talk some about arbitration and issues related to arbitration in regards to drafting and use of restrictive covenants, some considerations when drafting restrictive covenants, and finally, lessons learned from litigation, and then we'll move on to Q&A from there. So let's move to the next slide, please. This is a topic related to the executive order that President Biden issued in July of this year. Many of you may recall that on July 9th, President Biden issued this executive order in which he called upon the Federal Trade Commission to consider working to exercise its statutory rulemaking authority to what the executive order says, curtail the unfair use of non-compete clauses and other clauses or agreements that may unfairly limit worker mobility. Now, as background, this isn't the first time that there's been a call to the FTC to engage in this kind of analysis. Back when President Obama was in office, he issued a state call to action on the issue of non-competes. And exactly 18 months before this recent executive order by President Biden, the FTC conducted a day-long workshop, so to speak, regarding non-competes and whether they ought to be regulated in some form. The result of that is a 337-page transcript for those of you who may be interested in seeing it, in which there were no definitive conclusions reached and lots of different analyses and opinions on whether or not the FTC can or should engage in any rulemaking with regard to non-competes. So nothing happened really of substance during that 18-month period, and then literally 18 months to the day, in July of this year, President Biden issued his executive order. Now, it raises more questions, in my view, than it answers, because the executive order says, the FTC should look at the unfair use of non-compete clauses. Well, what does that mean? If the intent of the executive order were simply to ban non-competes outright, the use of some of the clauses in Section 5G of the order would be superfluous. And what is the scope of other clauses or agreements that may unfairly limit worker mobility? Does it include non-solicitation clauses? Does it include no hire provisions? What about non-association provisions that employers sometimes like to use? And finally, what effect would this executive order have on forfeiture for competition, an issue that Marcia is going to talk about in a few minutes. Also, it raises the question, do all non-compete covenants unfairly limit worker mobility? Or is this really designed to address things like low-wage agreements? Here in Illinois, the initial impetus for the Illinois Freedom to Work Act was the lawsuit that the Attorney General of Illinois filed against Jimmy John's, which had restricted its employees from working at other Subway shops for sandwich shops rather, for a 2-year period. That was viewed as unnecessarily harsh on low-wage workers and resulted in the enactment of the Illinois Freedom to Work Act in its initial form. the issue of non-competes was the only issue addressed at that time, but as we'll get into later, the Freedom to Work Act has been amended now to cover a much more broad scope. So the FTC, through this executive order, is supposed to work as well with the White House Competition Council, which is led by the director of the National Economic Council. Section 4 of the executive order sets forth what the goal of this working group is designed to address. So let's move to the next slide, please. Concurrent with the issuance of the executive order was a fact sheet issued by the White House. And the executive order, as you see here, includes 72 initiatives by more than a dozen federal agencies. So it was a really sweeping effort by the White House to create changes in the use and enforcement of non-competes. But I think that the goals here versus what's likely to happen practically are two different things. Here, it seems clear from the fact sheet that the intent was not to ban non-competes outright, because the fact sheet says ban or limit non-competes, and is designed, in a couple different places here. So, at this point, it's really a waiting game. We need to sort of stay tuned and see what, if anything, the FTC does here. Nothing of substance has happened in the last few months since the executive order was issued. And I think even if there is action taken by the FTC, it's quite likely that we will see legal challenges to any regulatory efforts. For one thing, obviously the executive order doesn't say how the non-competes should be limited. And the legal challenges, I think, are likely to focus on, first, the fact that non-competes are typically contract issues regulated by state law, and it's a state contract issue. And secondly, questions will arise as to whether or not the FTC actually has the authority to govern non-competes based on its rulemaking authority. That was a subject of discussion at the workshop 18 months ago or so. And I think that's likely to come up in the context of judicial challenges as well. So with that, I'm going to turn it over to Ruth to address proposed federal legislation.
Thank you, Andy. So, as Andy mentioned, in addition to the executive branch taking interest in non-competes, there's also been legislative activity with respect to non-competes on the federal front. In 2019, 2020, 2 bills were proposed in Congress to eliminate or significantly restrict non-competes. And both of them have actually just been recently reintroduced in 2021. One of the bills is the Freedom to Compete Act, which is a bipartisan bill that was introduced by Republican Senator Marco Rubio and Democrat Senator Maggie Hassan. And the bill essentially seeks to amend the Fair Labor Standards Act to ban non-competes for most non-exempt workers. The ban would essentially apply to employees who do not qualify for the executive, administrative, professional, and outside sales exemptions under the FLSA. And it would prohibit employers from enforcing or threatening to enforce a non-compete and from entering into or renewing non-competes with respect to such employees. The bill would give the Department of Labor enforcement authority, and they, just like they would enforce minimum wage and overtime violations, they would enforce, violations of the restrictive covenant. But as Andy just mentioned, and as I mentioned, this is a reintroduction of a bill that already was introduced in the past and didn't get much traction. So it's not clear that it's going to get much traction this time around either, but it was recently reintroduced. At around the same time, the Workforce Mobility Act, which is another bipartisan bill, was introduced both in the House and the Senate, and it also seeks to ban non-competes, but it's a little bit different. It has exceptions for the sale of a business or dissolution or disassociation from a partnership. Under the bill, enforcement responsibility would be placed with the FTC and the Department of Labor, and it would give folks private right of action to enforce it. And interestingly, with respect to the Workforce Mobility Act, There are some limitations to the restrictive covenants that can be entered into even in connection with the sale of a business. So while the buyer is permitted to enter into non-competes in connection with the sale, it's only with respect to the seller and senior executives who were employed at the time of the sale. And the senior executives need to be provided with, severance equivalent to a year of salary, and the non-compete period could only be for a year-long period. So it really does seek to limit even non-competes in the sale of a business, which is frankly more limited than what is even in effect in California right now. And California is commonly known as, one of the more restrictive jurisdictions in connections with non-competes. Next slide, please. So, but unless these bills are passed and the federal government takes action, the current state of affairs which would continue, which is that enforcement of restrictive covenants is governed by state law. It's a matter of contract. But while most jurisdictions enforce covenants not to compete, at least in some way, they have limitations, but they generally enforce them. There has been an increasing move among the states to, create more restrictions or to outright impose bans on non-competes. But putting aside those restrictions, the general rule, when jurisdictions look at non-competes is to assess the reasonableness of the restriction. And in looking at that, they look at the duration of the restriction, the geographic scope, and the substantive scope. Because for example, some jurisdictions require the employer to show that they have a legitimate business interest in the restriction that they're imposing. So why do you need this geographic scope? Why do you need this duration? Why are you imposing this restriction on this employee? But as I mentioned, the number of states that are really passing legislation now to create more concrete limitations beyond what the judicially recognized court imposed limitations is really increasing as time passes. I think last count, it was more than half of the states have some sort of legislation in place that deals with restrictive covenants and in particular non-competes. Next slide, please. So we're going to go over, pretty briefly a number of the trends. So some jurisdictions like Alabama, Florida, Georgia, Idaho, and Texas have statutes that govern the enforceability of non-competes, but they generally enforce them. So for example, Alabama frowns on non-compete agreements and really states that such agreements are void, but it has pretty broad statutory exceptions that permit such agreements if it's for the purpose of preserving a protectable interest, which goes back to what I said before. They kind of make you show, hey, this is why I need this. It's not just a carte blanche to do it. And the exceptions apply to, for example, an individual that holds a position unique to the management, organization, or service of the employer. It also has to do, there's one that deals with the sale of a business, so the time period is limited to 1 year if the restrictive covenant is in connection with that. Florida similarly requires employers to show a legitimate business interest, such as protection of trade secrets, protection of valuable confidential business information, protection of substantial relationships with specific clients and customers. Extraordinary or specialized training is another one. And interestingly, with Florida, they have the statute imposes specific time limits, ranges of presumed reasonability. So for reasonableness. So for example, if the restrictive covenant is not related to the sale of a business, then it's presumptively reasonable to have a restriction between 6 months and 2 years. If it is in connection with the sale of a business, then it's presumptively reasonable to have a restrictive covenant that's between 3 and 7 years long. So, I think in Florida, generally, it's a pretty employer-friendly jurisdiction with respect to restrictive covenants, but there are some limitations and you do need to be able to show, hey, this is why I need this. On the other end of the spectrum, a minority of jurisdictions just have an outright ban on non-competes. For example, California has one which basically says that any contract which restrains a person from engaging in a lawful profession, trade, or business of any kind is void. And the only exceptions are really the sale of a business or the dissolution of a partnership. And the California ban has also, been extended to include, been interpreted to include non-solicitation of customers covenants. North Dakota has a ban, Oklahoma has a ban, and Washington, D.C. recently passed legislation that is also effectively a ban on non-competes. It's not yet in effect. It keeps getting pushed, but it's also pretty broad, so it definitely shows that the trend here is to not have non-competes, or at least to severely restrict them. And then I think, as Andy mentioned, and we're going to get into in more detail, Illinois just passed a pretty sweeping law that also deals with restrictive covenants. Next slide, please. So, and I think Marcia is going to go over this in a little bit more detail and give some more examples, but there are different ways that the different state legislations, different state laws have dealt with the non-compete issue. Some new laws apply just going forward to new agreements. For example, the Washington, D.C. law would only apply going forward. So employers would still be allowed to enforce their existing agreements, but they just can't enter into new ones. And some apply going backwards. So it's pretty important to keep up with the current requirements in each state so that you know whether you can enforce your restrictive covenant or not, and whether you need to amend it. A lot of states have also implemented new procedural requirements. So for example, in DC, you need to provide within 90 days of implementation of the statute, once it goes into effect, you need to provide employees with notice of the statutory requirements, for example. Some of the statutes require the employer to provide the employee with information about the restrictive covenant before they accept the offer of employment. So it really just depends on the jurisdiction, but those are things to be cognizant of because these specific state requirements really vary significantly, and they can mean the difference between an enforceable restrictive covenant and a non-enforceable one, based just on, for example, whether you gave the employee sufficient notice in advance of them signing. And then many of the new statutes also impose penalties on employers for entering into prohibited agreements. For example, California doesn't really have any statutory penalties, but some of the new statutes do in other jurisdictions. And with that, I'm going to turn it over to Marcia.
Thank you, Ruth. So as a theme throughout this, we're obviously well aware that most companies would prefer to not have a separate non-compete for each state that they operate in. And so our theme here is to tell you the trends that exist in individual states so that you can think about and we can help you to think about how to have a restrictive covenant set of agreements that actually functions well for your company and it is adaptable to the various states in which you operate. So thinking about that, as Ruth talked about in both the federal proposed legislation that hasn't been passed and may never be passed, but also in the number of states, there is increasingly legislation that prohibits employers from using non-compete clauses with rank and file workers. And as you see on the slide, the definition of rank and file workers varies a lot from state to state. So in some states like Massachusetts, the prohibition is no non-compete clauses, no restrictive covenants with non-exempt employees. In a lot of other states, there's a salary threshold. So the employee has to be making more than, here we see 30,000, 50,000, 60,000 a year in order to, for an employer to be able to permissibly enter into a non-compete with that employee. And some of the reasons for that go back to studies that have been done in the last 10 years, both in government and in academia, that seem to show that non-compete restrictions for lower wage employees actually hold down wages and increase the poverty level in the U.S. And so a lot of states acting on that thought have put into effect these prohibitions. So for instance, we see some of our clients saying, we're not even going to think about asking employees who make less than $100,000 a year to sign non-compete agreements or restrictive covenants. And obviously, there's no magic to that number, and you know, in most states, it's entirely possible to require non-compete agreements for employees who don't make $100,000. But that's just an example of how some companies may be able to have a national program that allows them not to be too concerned about the details of each state as those rules change and evolve. Next slide, please. Molly, can we have the next slide? Great. Okay. Apparently I talked too long about the last slide, so I'll go to the next slide. Oh, sorry, go back. Okay. So the other development that we see is states that are imposing various procedural and substantive requirements, such as those that Ruth talked about, regardless of the income of the employees. So prior notice requirements are very common. Another element that we often see is a requirement that the employer pay all or a portion of the employee's salary while they're restricted from competing. And obviously the theory there is that if at least from the employer's perspective, if you're paying the person, then we certainly shouldn't be competing with you, is one way of looking at it. From the lawmaker's perspective, they're saying, well, if you expect them not to compete with you, you ought to be paying them something. And obviously consideration is a requirement for an enforceable restrictive covenant in virtually every state. But in some of this legislation, we're seeing the specific consideration being prescribed by legislation. Next slide, please. So we're going to talk in some detail about a new law in Illinois. And of course, we realize not all of you have a lot of employees in Illinois. But the reason that we've selected this is that, first of all, it's the newest of the comprehensive laws. And secondly, what we see is, in general, Illinois seems to be trying to become one of the states that is setting precedent when it comes to employee protective laws. So, of course, California is the most protective, and we see New York increasingly, New York State and New York City increasingly passing laws that are very, very protective of employees in a number of ways. And Illinois has always been close behind, and you know that may or may not be a good thing, but it seems that the legislature in Illinois is intent on passing more and more laws that enable it to say, yeah, we're protecting our Illinois employees as well. And the other reason that we're going to focus on this is that the newly amended Illinois Freedom to Work Act, it takes effect on January 1, 2022, and for any agreement entered into before that date, these rules don't apply. So that's one reason to think about it if you do have employees in Illinois. And the other reason is that it kind of throws in the kitchen sink as to all of the various limitations that it includes. So there is time to get an agreement in place before this law takes effect. And if you don't intend to do that, and it obviously isn't practical for many employers, then it's important to understand what's coming after January 1, because it may affect your national structure. And I'll turn it back to Andy to talk about the details of that and go to the next slide.
Thanks, Marcia. So I'm going to spend a few minutes going through some of the nuances of the Illinois law. As Marcia said, I think some of these principles are likely to be adopted in other states, and so it's important for all employers to be aware of the kinds of changes we're seeing as reflected through these amendments to the IFWA. In the past, Illinois had followed and has a long line of case law dealing with non-competes and non-solicits in the context of common law standards. And the IFWA now codifies a number of these issues. One is in the definition section, where there are actually two separate definitions for a covenant not to compete, as you can see on the slide. The first one, of course, is the more traditional type of non-compete used in the context of an employer seeking to preclude an employee from working somewhere else. The second sub-bullet point, an agreement that by its terms imposes adverse financial consequences on the former employee for post-termination competitive activities, wasn't given more breadth by the legislature when they spelled it out. But we think it's reasonable to conclude that that definition will encompass things like a forfeiture for competition doctrine within the context of an equity incentive plan, for example. And Marcia will talk more about that later. But clearly, this second definition wouldn't be necessary if the intent of the legislature was simply to address the more common practice of employers trying to restrict where employees go. There are a number of categories excluded from the statute with respect to what is or isn't a covenant not to compete. The purchase or sale of a business consistent with California law, like Ruth mentioned earlier, is one of those exceptions. So too are things like intellectual property agreements, confidentiality agreements. So there are other ways to restrict what employees can and can't do. And fortunately, the legislation is clear on some of those issues to give employers some protections. The statute itself, interestingly, was passed unanimously after a number of other bills in recent years designed to outlaw non-competes entirely failed. This was described as a compromise between not just both sides of the aisle in terms of the Illinois legislature, but also conflicts between state and federal courts on some of the issues that we'll talk about in a couple of minutes. And for the first time, this statute now addresses covenants not to solicit and defines them specifically here as outlined at the bottom of the slide. Next slide, please. So what are some of the new requirements? These are really important for employers to consider as the effective date of January 1st is coming up. The original bill, Senate Bill 672, was passed much earlier in the year. It took a while for Governor Pritzker to sign it, but he did sign the bill in August, and therefore the provisions of the IFWA, as Marcia said earlier, will take effect beginning the first of the year. Two of the most important ones are notice. So as you can see in the first slide, the employer has to provide a copy of the covenant at least 14 calendar days before employment commences, or at least 14 calendar days for review, for example, for those employees who are current employees. That's important because it may impact employers' decisions on the issuance of offer letters and when start dates may follow as a result of that. Commonly you send an offer letter and you expect a quick answer. If you're including a restrictive covenant as part of that process, you're going to want to, take into account this 14-day period so as not to suggest that there's any coercion or duress on your candidate in terms of accepting a position. The employee has the ability to sign shorter than the 14-day period, and that's not unlike releases of age discrimination claims under the ADEA and OWBPA. But again, I think you want to ensure that there's language in the agreement or in the offer letter that includes the agreement or refers to the agreement that makes it clear that the employee is signing voluntarily, has had sufficient time to review it, that 14 days is built in, et cetera. Secondly, the statute includes a specific requirement that employers advise employees or applicants in writing to consult with an attorney before entering into the covenant. And after the bill was passed, a client reached out and said, well, can we simply say that they have the right to consult with counsel before signing the covenant? And the answer is it's not clear. My hunch is that would be sufficient. The legislation in similar statutes is slightly different. So for example, in the Illinois Workplace Transparency Act, which was passed a couple of years ago, the language there requires, and deals with the timing and requirements of separation agreements, for example. The language there requires the employer to notify the employee in writing of his or her right to have an attorney review the agreement before its execution. It seems to me that telling the employee that they have the right to consult with counsel is close enough to telling them you should or must review with counsel. So I think that that may be one way to address that particular statutory requirement. But I will say that these are not requirements that employers should take lightly, because if you look at the language of the IFWA, there are a number of provisions throughout the act that say specifically that the failure to comply with a particular provision renders the covenant void and unenforceable. So the legislature made a point of enforcing the importance of each of these provisions in a way that employers, again, should be careful and mindful of ensuring that they follow them. Next slide, please. One of the things that the Illinois statute does, much like Marcia talked about earlier, is address minimum compensation thresholds. Here, the legislature provided a detailed explanation of what it is in terms of those thresholds through the actual or expected annualized rate of earnings. I won't go through all the details of that. There are more of them set forth in the statute, but it basically accounts for the salary and various other types of benefits to add up to the minimum thresholds. It's different between the type of covenant that you want to use. So $45,000 for non-solicitation covenants with the step increases every 5 years. Those step increases are $2,500 over the course of 5 years. And so the law extends out to 2037 in terms of these increases, such that by 2037, the minimum compensation threshold will be $52,500 for a non-solicitation covenant. The step increases for non-compete covenants are slightly higher. They're $5,000 every 5 years. So by the time we get to 2037, in January of that year, the minimum compensation threshold will need to be $90,000. Next slide, please. The Act also addresses the issue of COVID-related personnel actions. There's obviously been a lot of debate and press coverage about employers who want to restrict employees after having laid them off or terminated them as a result of the pandemic. And the legislature sought to address that question by including restrictions through the terms of the Act. So there's a separate section 10C of the Act that addresses terminations, furloughs, or layoffs as a result of the pandemic or similar circumstances. Let's hope there's not a second pandemic coming anytime soon, but the IFWA addresses that. It's not clear what other circumstances that are similar to the pandemic is intended to mean, but I think that would be interpreted fairly narrowly. The exception to that is sort of like a garden leave provision, where if the employer is willing to pay the employee's base salary minus any subsequent employment from compensation rather from subsequent employment, then that's one way that an employer can nonetheless use a non-compete despite having laid somebody off or terminated them during the pandemic. Next slide, please. The remedies in private and governmental litigation related to the IFWA are really important for employers. This is a provision, the first bullet point addresses new remedies in private litigation. And the first sub-bullet point there applies to employer-initiated civil actions and arbitrations. The result that the legislature wanted was that the employee who prevails on a claim like that shall recover all costs and all reasonable attorney's fees. Employers need to be mindful of that provision because there's obviously an imbalance in the legislature's mind and in the minds of many courts of the bargaining power and leverage that employers have over their employees. So what the legislature did here is essentially have a one-way fee shifting provision. Now, it doesn't apply in the event that an employee initiates a declaratory judgment action, for example, saying to a court, I don't think my non-compete is enforceable and therefore I should go, I should be allowed to go work for a competitor. So it's limited to those actions in which the employer either initiates the lawsuit or files counterclaims against the lawsuit that the employee files. Whether that will have a chilling effect on employers who may be on the fence about whether their covenant is enforceable remains to be seen, but it's something that certainly employers should take into account because you run that risk now that didn't exist in the past. You know, there was a school of thought that employers could just pursue enforcement of their non-compete, and if they didn't win, so be it, but at least they'd have the opportunity to negotiate settlements with the employee or come to some other type of agreements on restrictive covenants that may be effective simply in filing the lawsuit. That's still the case. Excuse me. That's still the case, but I think that employers need to be mindful of this additional risk in terms of fee shifting, and we'll talk a little bit about that later in the session as well. There's also a new section now for state enforcement for those claims that the Illinois Attorney General might view as pattern or practice claims. The remedies there include damages to the state as well as restitution and injunctive relief. And the civil penalties are for each person. And so those can add up fairly quickly as well. Next slide, please. The statute now sets forth adequate consideration. This it was the subject of a lot of debate between state and federal courts in Illinois, as those of you who are familiar with the history know. In the Fifield case and the McInnes case, those are two Illinois appellate court decisions. Illinois many years ago laid out, at least at the state level, the concept that you needed to work for your employer for 2 years or more for there to be sufficient consideration, at least if that were the only consideration for the covenant not to compete. Now, those cases all arose in the context only of covenants not to compete. Federal courts in Illinois had often rejected the notion that a 2-year minimum employment was necessary because in the view of many courts, it's simply arbitrary. Why should somebody who's been there for 2 years and a day have an enforceable covenant, but not somebody who's been there for 1 year and 11 months? The differences between what those employees know wouldn't be significant enough to justify this kind of arbitrary line. The Illinois Supreme Court declined to take up either the Fifield or the McInnes case, and so it had not issued any guidance. And part of the compromise that I mentioned earlier among the legislature was, okay, how do we kind of harmonize these differences between the Illinois state and federal courts' decisions with regard to what should or shouldn't be adequate consideration for the covenant. So here on the slide, we've identified the ways in which the statute lays out potentially sufficient consideration. 2 years by itself after signing the covenant is enough, but there are other options such as additional professional or financial benefits, or merely professional or financial benefits adequate by themselves. The legislature did not provide further guidance on what those benefits might mean, but obviously bonuses, one-time payments, in exchange for the covenants, et cetera, should suffice to meet those thresholds. The law also goes into detail in codifying enforceability with respect to what the employer's legitimate business interest needs to be. That was the standard used by the Illinois Supreme Court in the reliable fire case from a decade or so ago. And there's, again, it's kind of a balancing test based on all the circumstances of the individual case. There's not one factor that carries any more weight than the other. That's consistent with reliable fire. And the statute says specifically, a contract can be reasonable and valid under one set of circumstances and unreasonable and invalid under another set of circumstances. Obviously, because the statute hasn't become effective yet, it would be interesting to see how a court would address that provision in the context of an employer that uses a non-compete in two different ways at the same time. One, to try to restrict the employee's employment, and secondly, as part of an incentive plan or equity plan designed for forfeiture for competition. The next slide, please. Reformation is also something that the legislature now specifically addresses. Here too, the common law principles are largely included in the statute, but the statute begins, this section 35 begins rather, by making the sort of broad comment that extensive reformation may be against the public policy, and specifically provides the court the opportunity to rely on this section to say, I'm not going to rewrite a contract that's overbroad. So this should be, a cautionary sign for employers to contemplate the breadth of the covenant that you may be seeking from your employees, because obviously the narrower and more tailored it is to the particular employee, the easier it is to try to defend that covenant in court by saying, look, we're not overreaching. We tried to design this specific to this particular employee's role, the scope of our competition, et cetera. The statute does provide the court the ability to reform or sever provisions, which is also consistent with how Illinois courts had assessed that issue prior to enactment of the statute. And then the statute lays out several factors relevant to determine whether reformation is appropriate, and those are all listed here. The last one I think is particularly noteworthy. We always think it's a best practice to ensure that your covenant specifically provides for the court to modify, sever, reform, et cetera, in the event that the court concludes that the provisions are overbroad.
Thank you, Andy. So in this section, I'm going to talk about forfeitures and clawbacks for competition. And Andy has alluded to these provisions when talking about the Illinois law and others. And a number of companies have decided that they may not impose on their employees actual restrictive covenants not to compete, but instead it will be a condition of receiving often very lucrative equity awards or incentive awards that go only to generally, significantly well-paid executives. And often that makes a lot of sense for a couple of reasons. One is that those executives are the people who are likely to cause the most damage in a lot of cases if they were to go to a competitor. And secondly, it makes sense from a just sort of a normal logic point of view, public policy, however you want to put it, that, gosh, if the current employer is giving an executive these really significant valued benefits or monetary payments, that the least the executive can do is refrain from damaging the employer after they leave by quickly going to a competitor. So increasingly and really very commonly, we see companies including in their award agreements or in their plans terms that say you would forfeit compensation going forward if you join a competitor, or even that the company may claw back, that is, demand repayment of payments that have already been made if the executive goes to work for a competitor or establishes their own competitive business. So are those restrictions enforceable? Can the employer impose a forfeiture or even demand repayment of benefits? It's a very complicated question, so we're going to talk about it for a bit. So generally, pension benefits or other benefits that are subject to ERISA vesting and ERISA guarantees cannot be forfeited. Those cannot be made dependent on conforming with a non-compete restriction. But for top hat type benefits or welfare benefits that are a matter of plan language or contract language, it doesn't generally violate any law for an employer to condition, to say that it's a condition of receiving or retaining those benefits that the executive or the employee must refrain from going to a competing enterprise. Next slide, please. So then things get a little complicated. So first you have the wording of the contract or the plan, is that, and you have to look at whether that language is as clear as you, the employer, would want it to be, both in providing what type of action, what type of competition is prohibited, and in providing the conditions or the processes that are put into place in order to impose a forfeiture or to demand a repayment. In addition, you have state wage protection laws, and most of you will be familiar with those. Certainly, California employers, Illinois employers, and New York employers, and many other states. Most states have a wage protection law that says an employer can't take back money that they've given to an employee. Sometimes there's an exception for executives, but generally we view these provisions as enforceable, not because you can take back money, but rather because the money or the benefits or the stock interests, the equity interests, were given in the first place. They were made conditional on the executive's agreement to not compete or not solicit, and the executive's continued compliance with that obligation. So just to be clear, again, we're not saying that state law allows employers to take back money or benefits they've given, but rather if you properly make those benefits or those payments conditional on complying with non-competition or other restrictive covenants, that will often be enforceable. So then we get to, well, is the restriction that the employer is trying to impose, is that a restriction that the state or that the state law would recognize, or does that even matter? So here's where we get to the employee choice rule and the reasonableness rule, and I'm going to ask us to go to the next slide. So the employee choice rule is a term that's used to describe the following reasoning. And the reasoning is, well, if all that happens is that you forfeit benefits that you wouldn't get without the restrictive covenant conditions, that may be okay. And the reasoning is that the employee is not prevented from competing. The employee is not prevented from doing anything. Rather, the employee will simply lose their right to get these benefits or these payments. And there are a number of states that currently, where the state law and the courts, not usually by statute, but where the court opinions have recognized that and have said we will enforce a forfeiture, or we will enforce a clawback, as long as the person can compete and they're not prevented from actually doing the competitive activity. We don't mind if they forfeit benefits or if those benefits are clawed back. And the other side, the reasonableness standard, there are states that say, actually, even if all you're doing is imposing a monetary penalty on the person, even if all you're doing is making a benefit conditional on not competing, we still view that as a restriction on the employee's activity, because in reality, it's likely to affect what the employee does. And therefore, we are not going to enforce the forfeiture or the clawback unless we look at the restriction and we think that it's reasonable under our state law. And frankly, it's really hard to say that one set of reasoning is right and one set of reasoning is wrong. All you can do is look at the states that you're in and the evolving laws and decide what to do with your own restrictions as you look at that. And most employers seem to conclude that, well, if there's some chance of it being enforced, it's definitely worth putting into our agreements, because it will have a chilling effect, which we intend, which is that the employer will think, the employee will think twice before going to a competitor quickly, because they don't want to lose those benefits or have to pay anything back. Next slide, please. So let's look at the current law in a few bellwether states. So in New York, as you saw on the previous page in the chart, New York subscribes to the employee choice rule, at least currently, and up until 2020. And as it says here, the forfeiture would be enforced without regard to reasonableness if the employee has an effective choice. Now, New York courts consider that the employee does not have that choice if the employee is involuntarily terminated without cause. And so if a New York-based employer wants to, or a plan that applies New York law, wants to enforce a forfeiture or a clawback on an employee who it has involuntarily terminated without cause, in that case, the employer will have to defend the reasonableness of the restriction. And in addition, if the New York court views the restriction as not really allowing a choice, again, the employer would have to prove the reasonableness of the restriction. So stated positively, the restriction for forfeiture, the forfeiture and clawback may still be enforceable in New York, even under the reasonableness standard, but if you do everything right, and if everything goes right, you won't have to prove that the restriction is reasonable. So going to the other side of the country and the other extreme, in California, as you all know, restrictive covenants are void, and forfeiture provisions are viewed just like restrictive covenants, and they're also void. And that was decided a long, long time ago in 1965, and that remains the law. So Ruth will talk a little bit about a narrow path through that, but for the most part, these restrictions are void. Next slide, please. So then we get to Illinois, and these cases all predate the current Illinois law. So the question is, so in Illinois, this employee choice rule has been what the federal courts anyway have interpreted Illinois law to provide. And they say, well, we're rewarding loyalty, we're rewarding a long-term stake in the company, and that's okay because the employee, the executive, can still throw that away and go to work for a competitor, but that's a choice they're making. And as it's said in the Viad Corp versus Houghton, the forfeiture clause didn't impoverish the defendants, it just imposed a cost. Next slide. So if we look at the new Illinois law's definition of covenant not to compete, as Andy had discussed, any covenant that by its terms imposes an adverse financial consequence on the former employee for engaging in competitive activities is a covenant not to compete. So a forfeiture clause and a clawback clause would indeed impose an adverse financial consequence, and therefore it would be a covenant not to compete covered by the new law. What we don't know yet is whether the courts will still view fairly favorably the reasonableness of covenants under Illinois law, even as they apply the new law. And it's entirely possible that forfeitures and clawbacks may still be enforceable in Illinois under the new law, but we don't know exactly how it's going to be interpreted. All right, I'm going to turn it back to Ruth to talk about some considerations now that you have all these details, how are you going to draft your restrictive covenant to make it work? Thank you, Ruth, for figuring that out.
Thank you, Marcia. So I think, as Marcia mentioned earlier in the webinar, most employers want to have a one size fits all or close to one size fits all sort of set of documents that they want to use with their employees, and it's becoming increasingly difficult to do that because of the different state requirements. But there are ways to have maybe a few sets of documents that you can use based on sort of parallel requirements in various jurisdictions. If you don't want to go to the highest common denominator and just use the most restrictive restrictions, which most people don't want to do. But some things to take into account when drafting restrictive covenants and employee agreements generally is that most states allow non-disclosure agreements that protect confidential and proprietary information and allow employers to sort of pretty broadly restrict competition based on the use of trade secrets. So sometimes it's hard to prove what a trade secret is in many jurisdictions, like in California, but you can include a restrictive covenant that is based on, prohibiting an employee from competing using your trade secrets. And a lot of employers don't include that in their confidentiality agreements. They have confidentiality provisions, but they don't include the non-compete part of it. And there's really no reason not to include it, frankly, because in most jurisdictions, it's enforceable. The other issue is non-solicitation of customers and clients covenants. And those are often treated differently and more favorably than covenants not to compete. Not in jurisdictions like California. California is still, it's a no-no, even with respect to customers. But for example, Oregon, which has fairly detailed restrictions on non-compete, such as an 18-month post-employment limitation on duration and things like that, actually treats non-solicitation of customers and clients covenants differently. And so that's a good thing to know, because a lot of clients, a lot of companies, if you really think about your needs, you might not need a non-compete. You might need a more, and it's easier to have a non-solicitation of customers covenant that applies, across the board in almost all jurisdictions. It's almost easier to do that than to have a non-compete. And you might get more bang for your buck doing that, because it's a lot easier to enforce, because inherently, usually, there is a legitimate business interest in having someone not solicit the customers, especially if you draft it in such a way where it's customers with whom they dealt or with whom they were aware. So there are ways to do it, but that's definitely a restrictive covenant that's worth considering. And sometimes it's worth not having a non-compete and just having that. And I think a lot of employers have sort of drawn that conclusion themselves and have started moving in that direction. And then there's also the non-solicitation of employees restrictive covenants, which are, referred to as anti-rating covenants. And those, in my experience, are by and large also enforceable. California used to be pretty clear that it was enforceable. There's recent case law which demonstrates that there's a split in authority among the courts of appeal as to whether non-solicitation of employees covenants are valid. So employers are sort of thinking twice about whether to include such provisions in their agreements, but so far it's not. The trend of the cases is that it's not enforceable, but it's not as clear cut. But in most jurisdictions, it is enforceable, and those are also useful tools to include in your restrictive covenants. So non-competes, the point being, non-competes are not the end all be all. They're a good tool, they're a useful tool, they're sometimes really important to have, but there are other ways to protect the company as well. And it's pretty important to think those through and to think about what your needs really are when drafting restrictive covenants agreements. Next slide, please. One interesting issue to think about is that unless it's prohibited by state law, you can be strategic about selecting choice of law and venue provisions. Now, you usually want to have a jurisdiction that has some relationship to the employment relation. So it shouldn't just be, something totally out of the blue that has nothing to do with anything. But choice of law provisions can matter a lot because of the differences in jurisdictions and how they view restrictive covenants and how they interpret them. And this comes into play a little bit in California because California in 2017, a law took effect, Labor Code Section 925, that basically prohibits employers from requiring employees who primarily reside and work in California as a condition of employment to agree to a non-California choice of law or forum selection clause. It used to be that some employers tried to get around the California restrictive covenants requirements by having non-California choice of law provisions. And, it was hit or miss, and usually a miss because California public policy is pretty strong on, no non-competes and no non-solicitation of customers covenants. But the interesting thing about Labor Code 925 is that it included a provision that basically says that this prohibition does not apply if the employee is individually represented by legal counsel and negotiating the terms of an agreement that has this venue or governing law provision. And so it hasn't been ruled upon really by the courts yet, but there is this potential opportunity if it's really important to have a non-compete or a non-solicitation covenant to have a different law govern if the employee is represented by counsel. There's no guarantee that it'll work because, like I said, California public policy is pretty strong against having California employees be subject to such restrictions, but it arguably could work because Section 925 says that, you can use outside of California laws for California employees if they're represented by counsel. The next consideration to think about is when you're entering into restrictive covenants. So most employers, you enter into a restrictive covenant at the beginning of the employment relationship, and then everyone sort of forgets about it until the end of the relationship. And then the employee violates it, and then they come back and say, well, I didn't remember this. This is 20 years ago, and it's not valid, or, whatever it is that happens. So a lot of, the best practice is often to have employees reaffirm their obligations. Or, for example, maybe you're paying them a big bonus and now you want to impose a non-compete, which is something that you didn't want to do at the beginning of the relationship. So one important thing to take into account is that while most jurisdictions say at-will employment, at the beginning of the relationship is adequate consideration for entering into the restrictive covenant, that's not necessarily the case if you're entering into a restrictive covenant in the middle of the employment relationship. So for example, North Carolina, courts have found that continued at-will employment is not sufficient. But for example, if you provide employment for a specific duration, that might be sufficient consideration. And a lot of jurisdictions have actually sort of come out saying, well, if the employee worked for you for a long period of time after the restrictive covenant, then it's okay and there is sufficient consideration. But unless you have a contract for a specified term, you don't have control over that. And so it can get a little dicey. So it's just something to consider, the jurisdictional requirements in connection with restrictive covenants and consideration. And with that, I'm going to pass it on to Andy to talk a little bit more about drafting considerations.
Thanks, Ruth. Just in the past couple of years, we've had non-compete cases in Michigan, Texas, Georgia, Florida, Illinois, and I'm sure I've left out a couple jurisdictions. And one thing we've seen there, of course, is the variations in the standards that are applied that Marcia and Ruth have talked about, from state to state. And, actually, if we can go back to the prior slide, Molly, I wanted to address the bottom bullet point there about the types of restrictions, because to add on to what Ruth has said, in Florida, for example, there are specified statutory provisions that address the employer's legitimate business interests that, for example, don't exactly match those specified in the Illinois statute that I talked about earlier. So in terms of, from the employer's perspective, when thinking through, okay, what type of restrictions do I want to put on there, understanding the importance of that individual's position is important. Another anecdote is we recently prosecuted a non-compete case where the individual had signed a non-compete early on in her employment, which was 25 or so years ago. And over time, she moved up through the chain and other covenants were presented, but she ultimately didn't sign them for one reason or another, or the company couldn't find a signed copy of the agreement. But her role ultimately evolved into one where she was intimately familiar with the company's most important trade secrets. And so that's the kind of occasion that Ruth mentioned where, through the promotion process, you may have a very easy opportunity to update a prior covenant or to audit your records to ensure that you have something signed and in writing from the employee. Now, depending on the position, the question then becomes, should we require a non-compete for somebody, for example, who's in a sales role? And, in our experience, a lot of times the issue is not so much the competition with competitors as it is perhaps sales to particular customers with whom that employee is intimately familiar with their needs, with pricing issues, with long-term strategies of the current employer and how that may benefit the future employer. Are there specific products that are really the focus of that employee's sales that could be, again, more narrowly tailored to limit the person's ability to work on a particular product or product line without going so far as to try to, restrict that person from working for a competitor in any capacity? And the reason that's important is because of what I call the janitor rule, and some courts have mentioned that as well. There is a case here in the Northern District of Illinois from a few years ago where a judge completely refused to enforce a non-compete agreement, even though the individual was a rather high-ranking employee. And the problem with the covenant from the court's perspective was that it said, in effect, it meant that the employee couldn't work for a competitor. And the court made a point of this in the opinion of saying it restricted the employee without regard to whether the position that she now holds is similar to the one that she held with her former employer. And then the court said, essentially, this means that the employee couldn't work for the new employer, even as a janitor. And the court acknowledged that, of course, that this high-ranking person wasn't going to be working for a janitor for the new employer. But given the imbalance in bargaining power and leverage that employers have over their employees, the court declined under Illinois law to take the step of trying to reform or sever the agreement. And the court said the fact that an employee is higher level may justify broader restrictions if that is necessary to protect the employer's legitimate interests. However, it will never justify a limitless restriction such as the one in the present case. And it's a good case, that employers need to be aware of in terms of the drafting process, because if you overreach, you run the risk of a judge taking the step. And, in light of the recent amendments under Illinois law to the Freedom to Work Act that essentially say there may be instances in which, reformation would violate public policy, I think employers need to be cautious about trying not to overreach in these circumstances. So trying to tie the scope of the restriction to what the employee does or has done for you as an employer, I think is a good step. I'll send it back to Ruth for the next slide.
So there are a few additional considerations in drafting restrictive covenants. And some of these things are often forgotten, but they're sort of good provisions to have in the agreement. So one of them would be to include a tolling provision in the event of a breach, so that the restrictive period is extended by the amount of time the covenant was breached. Sometimes you have an employee terminate, breach, then you're in litigation for a while, and the covenant is running and running. And at the end of the litigation, the restrictive period might be over. But you've been litigating this conduct, and you want the period of time to be extended based on the amount of time that they were in breach. So that's always a good provision to include. And there's really no reason not to include it. It's just an extra level of protection. It's a good idea to call out injunctive relief as a remedy for a breach, because oftentimes that's what you're initially going in for. It's also a good idea to specify a list of legitimate business interests. It doesn't need to be an exhaustive list, but if you identify it and think about it up front, it's helpful down the line. And if the employee is acknowledging the legitimate business interests, then it's even better, because a lot of jurisdictions require you to identify legitimate business interests. If it's in the agreement, it makes the whole thing a lot stronger. You also want to ensure that the agreement explicitly calls for reformation. Different jurisdictions have different rules about blue penciling agreements, but you want the agreement to say it can be reformed, because the worst thing that can happen is for a court to say, well, I think you overreached, and so therefore the whole thing is not valid. You rather the court say, I'll enforce the restriction for this length of time instead of this length of time, or I'll limit it to this geographic region where I actually do think you have a legitimate business interest. And so including that in the agreement as an agreed upon provision is a helpful thing to do. You also usually want to include a severability clause, that if a court finds that a certain part of your restriction is not valid, then it's severable from others. So for example, if the court were to find that the non-compete is not valid for whatever reason, then at least maybe the non-solicitation of customers or employees would be valid. Depending on the jurisdiction, including pro-employer language on fees and costs if the employer prevails is a good idea, because it's an extra deterrent for the employee. And it's a good idea to train recruiters, interviewers, HR teams, and management on the new state law requirements, especially in those states where you need to provide notice before the employee accepts the job offer. Because I think I mentioned this before, if you miss that, and it's easy to miss if you are operating in multiple jurisdictions, it could tank the whole thing. It could just make your entire restrictive covenant subject to challenge. And it's sort of one of those things that it's an easy fix if you train and you are aware of the requirements. And likewise, ensuring that offer letters and employment agreements satisfy the state law requirements in terms of if there's specific notice language or things like that. Next slide, please. Another interesting consideration has to do with arbitration provisions. Restrictive covenants litigation tends to be oftentimes pretty emotional, intense, costly. It can be public. There can be embarrassing things that come out. It tends to be bring out emotions in my experience. And so sometimes there are advantages to having such litigation and arbitration, and sometimes there aren't. And it's sort of a personal choice for every employer about how they want to handle it, because oftentimes you want to get an injunction. So if you want to get an injunction, you're going to go to court. But the other consideration is that if your employee is violating a non-compete or soliciting your employees or soliciting your customers at their new employer, you're often going to want to add the new employer in the litigation. You're going to want to sue them both, because the new employer is also a bad actor. And so if you are subject to an arbitration provision, a mandatory arbitration provision that requires arbitration, and the new employer is a non-signatory, you might have to arbitrate the individual's claims and litigate in court the employer's claims outside of an injunction if you're just litigating, the merits. And that's not, usually optimal, unless there's some really embarrassing fact or, things you want to keep under wraps in an arbitration. And so a lot of employers should consider whether they want to carve out of any existing arbitration agreements litigation over restrictive covenants for that reason, because usually in my experience, it involves the new employer. And so you're going to be stuck in a kind of a catch-22 where you might have to dismiss the new employer and just go to arbitration, or you're going to be litigating in two forums. And some of the considerations in, deciding whether you want to litigate these cases in arbitration or in court is, arbitration is obviously more confidential. Discovery tends to be a little bit more streamlined. It's a little bit less adversarial, and you have a trier of fact with subject matter expertise rather than a jury, which can be fairly unpredictable. But like I mentioned, the disadvantage is that these kinds of litigations involve third parties, and the cost of litigation can be high because of the arbitrator's cost. Next slide, please. So, basically, I don't want to restate what I just said, but there are a number of different options in dealing with the arbitration clause. One is to carve it out. One is to have a unilateral arbitration election clause where only the employer can elect arbitration. But this is not necessarily going to fly in all jurisdictions. Like in California, I think that this could be subject to, pretty significant unconscionability standards. You can exclude from the arbitration clause litigation where it involves claims involving third parties. It's a little hard to draft around that, but it's possible. So there are ways to deal with it, but it's definitely something to think about. Next slide, please. And now I'm going to turn it to Andy to talk about lessons learned from litigation.
Thanks, Ruth. So we're going to conclude before the Q&A and wrapping up here with some thoughts on lessons that we've learned through the course of these kinds of cases. The first is that it's helpful to have an alert that identifies when employees download sensitive or large volumes of information to the extent that's feasible. The case that Ruth and I are litigating a case now in Florida where an employer had such a notice in effect. And when an employee tried to download information through a firewall as part of his and a large group's departure for a competitor, the company got notice of that, and that helped sort of alert them to the fact that there may be a concern about which they needed to take action. So having that kind of protection in place is certainly helpful to prevent these kinds of improper disclosures. And that's often the crux of the dispute we find in non-compete cases, is that employers are often extremely concerned about the misappropriation of their trade secrets and other confidential information. Sometimes it's not so much the fact that the employee might go to the competitor, it's going to the competitor with having taken some other action that calls into question what their motives are. So that kind of protection is a good one to have. Similarly, even before the departure of an employee, having the protocols in place that allow the employer to show that protected information is limited to those who have access, because that's one of the elements of a trade secrets claim, is showing that the employer takes steps to limit access. If everybody can see it at the company, then it's not truly a trade secret, right? Also, having employees sign certifications indicating the return or deletion of company property is important. And then acting quickly and decisively when companies become aware of misconduct. I think that we've seen plenty of instances where employees depart for competitors and then claim later they didn't remember that they had a non-compete or a non-solicitation covenant. The former employer didn't take action at the time of their departure to remind them of those covenants. And as a result of that, sometimes inadvertently or otherwise, employers run into obstacles when trying to enforce these covenants. So for example, if somebody signs a covenant and then leaves the company 25 years later, it's quite possible that they either won't remember that they signed a covenant, and or won't have a copy of what they sign. So it's always a good practice for the employer, especially for high-ranking and important employees, when those employees depart. I think having as part of that departure checklist to send a letter reminding the employee of their covenant and attaching a copy of that covenant is important to do. As many of you know, if you've worked with outside counsel, that's often the first step that precedes actual litigation, is the threat letter attaching the covenant, reminding the employee of the covenant, and insisting on either a written response or that the employee cease and desist. And same for the new employer in terms of potential tortious interference claims. But some of those issues can be alleviated, I think, if just as a matter of practice, the employer sends those kinds of reminder letters at the time the employee initially departs, not after misconduct may first be discovered. The point that Ruth made about training is also important. It's often the case that employees sign their covenants and then years pass and nothing happens in the interim. And so reminding employees of confidentiality obligations, documenting that, requiring them to certify that they've gone through the training, whether it's on an annual or other periodic basis, is another important step that we think is helpful here. So those are a couple lessons that we've learned from litigation and I wanted to pass on. I know we only have a few minutes left. I don't know if there are any questions. If not, Ruth or Marcia, you may have other thoughts on lessons learned from litigation that you may want to share as well. And if not, oh, go ahead, Marcia.
I'm gonna ask Ruth a question. So in in the earlier section, Ruth, you quite rightly suggested that a customer restriction could be more enforceable than a full non-compete. And one of the things that I personally like about that is that it's easier to actually often draft a good customer restriction than it is to draft a good and thorough non-compete. And then you talked about non-solicitation of employees, and that is a really good provision. But what are some of the challenges you run into in enforcing those through litigation?
The non-solicitation of employees in particular?
Yeah.
So one of the major ones is damages. A lot of times you'll have employees leave a company and try to raid all their coworkers to leave with them. The thing is, they don't always go. And so the employees that are leaving cause a big kerfuffle and a big mess and, make a big show of leaving and, try to solicit people. But a lot of times the company is able to, persuade its employees not to leave. So sometimes it's hard to establish damages in connection with the restriction if the employees don't leave. Now, if the employer needs to pay retention bonuses, increase salaries, try to compete with the salary or the compensation that was being offered by the competitor, then you have some built-in damages. But sometimes that's just not the case. Sometimes they're just not successful and you don't really have damages. And especially in a jurisdiction like California where non-competes aren't valid, even the employees who leave, if they leave, what are your damages from them leaving? Like you have to identify what your damages are, and it isn't necessarily going to be lost business because they're allowed to leave and compete. And so it's oftentimes very hard to establish damages in my experience in these cases. Sometimes it's easy. Sometimes you just know they paid a bunch of retention bonuses and it's pretty simple, and sometimes it's not. But that's one of the big challenges that I found. The other one is proving solicitation. If people actually leave with each other, in some jurisdictions there are like no hire provisions, and you can have sort of more fulsome limitations on it, on employees leaving. But in California, for example, no hire restrictions are not valid because they're tantamount to covenants that compete. So you can only have a non-solicitation of employees covenant. Now, how do you prove if two employees left together? It's sometimes difficult to prove that one solicited the other. Sometimes it's easy. Sometimes you have text messages, or it's pretty clear that they approached a lot of people and you're able to prove it. Because some people left and some people didn't. But sometimes it's not as easy because they can just say, no, we were talking. No one solicited the other person. And if there's no written evidence of it, it becomes a little bit more difficult. So those are the two major challenges that I've come across. With respect to enforcing non-solicitation of customers' covenants, I think the solicitation piece is sometimes hard if it was all done verbally, because most companies don't want to drag their customers and clients into litigation. And so they don't want to subpoena the customer and say, hey, you told me that they solicited you and that's why you left, because the customer is really not going to appreciate that. And it can ruin your business relationship down the line. And so that's one of the challenges that I found in enforcing those kinds of covenants.
Yep. Thanks, Ruth. Just a reminder that our wonderful colleagues in our employee benefits group will again be presenting next week on latest ERISA developments and trends. The fourth and I think final installment of Benefits and Compensation University for this year. CLE credit is available for that program as well. And then I will close with some final remarks. This wraps up today's program. And on behalf of Mayor Brown and my colleagues, Ruth and Marcia, thank you for your time. We hope you found this program useful.